The Renters' Rights Bill has sharp teeth, and these sharp teeth are going to make it actually relatively easy for local councils to impose penalties of up to £40,000 on landlords and letting agents who break some of the rules that are in the Renters' Rights Bill. And to make things worse for landlords, tenants will also be able to apply to the first tier tribunal to have the last 2 years' rent, well, as a maximum, to be repaid by the landlord if the landlord doesn't comply with a whole long list of obligations. So, if you're a landlord or a letting agent, do you know what these obligations are? Do you know what you need to get ready for? Because ignorance of the law is no defense. But I'm going to make it easy for you to know what it is that you need to comply with. And in this video, I break it all down for you. So you will know which obligations at the beginning of the tenancy, in the middle of the tenancy, and even at the end of the tenancy that you need to comply with. And as a bonus at the end, I'll explain how landlords and agents can appeal against these penalties. Well, who am I? I'm Suzanne Smith, lawyer turned landlord, and I run the Independent Landlord website and this YouTube channel to provide landlords, letting agents, property businesses with reliable information to help you stay on the right side of the law, as well as helping landlords with the practical side of property management. You can keep up to date for free with pretty much everything that's going on in the private rented sector by signing up for my weekly newsletter at theindependentlandlord.com/subscribe. Right, let's get started. First things first. What penalties can local councils impose on landlords and letting agents? Well, the Renters' Rights Bill would give local councils the right to impose a financial penalty on landlords and letting agents if they are satisfied beyond reasonable doubt that the relevant person has broken some of the obligations in the Renters' Rights Bill. And beyond reasonable doubt, you might have heard of it before, it's the criminal standard, which means if there's a small doubt about whether or not the landlord actually did it or letting agent, then it's not proven. So that's a really high bar. However, some of the penalties, including rental discrimination against families and people who receive benefits, well, they only require the local council to be satisfied on a balance of probabilities, which means more likely than not, 51%. So that's actually quite a low bar. So what penalties can the local councils impose? Well, for a first or a minor breach, the council can impose a civil penalty of up to £7,000. And for serious or repeated breaches, the council can impose a penalty up to £40,000. For serious and repeated non-compliance, the councils also have the option of applying for a criminal prosecution, which might lead to unlimited fines for the landlord or for the letting agent. But imposing civil penalties is a lot easier for a local authority, and as a result, they're likely to be very popular with local councils, not least because they'll get to keep the money. And the important thing with a civil penalty is that the council can impose it without a court hearing. So it's a bit like a parking ticket. However, the landlord will be able to make representations before it's formally served on them. But I'll go into that in a bit more detail later. But it will be a lot easier for councils to do this than criminal prosecution. And as councils will be able to keep the money that they receive from the penalties they collect, it's likely that we're going to see a big ramp up in enforcement activity. So we need to be ready and we need to make sure we understand our obligations. So letting agents, you need to make sure you understand this. The landlords, your letting agents might not understand the rules because they're quite complicated. So it's important that you invest the time to understand it for yourself. So you know if you're doing the right things and if your letting agent's doing the right things. And you can do that by watching the rest of this video. The Renters' Rights Bill abolishes fixed-term tenancies, and they'll all automatically become periodic on the commencement date. So once the Renters' Rights Act is in force, If you let a property to a tenant and use one of the old AST agreements with the minimum period, fixed term period, well, you could get a fine because that's called purporting to let for a fixed term. And that financial penalty is up to £7,000. And also, if you want to let on a handshake basis, say to a friend or a family member, without giving the tenant a written statement of the tenancy, that will put you at risk of a 7,000 fine as well. And ditto, if you let a property without having an active entry on the landlord database when that comes into effect, as both as a landlord and for the property itself, or if you provide incorrect information to the database knowingly or recklessly. And also, if you don't have valid entries on the database, it will be very difficult for you to get repossession of your property because you won't be able to use most of the grounds under Section 8. And it will be the same if you don't join the PRS Landlord Ombudsman once that comes into force. And for those last two, the tenant or the council could apply to the first tier tribunal for a rent repayment order for up to 2 years' rent. If you've watched any of my other videos, you'll know that there's a lot of obligations regarding rent in the Renters' Rights Bill. So, for instance, if you don't state the proposed rent in the listing, advert, or offer, then the council could slap a 7 grand notice on you, a penalty notice on you. And if you accept an offer over that proposed rent, then you could be fined 7,000 for that as well. And don't forget that if you do it more than once, you could have repeat fines and they could be increased to £40,000. And our new friend, the prohibited pre-tenancy payment of rent, which I've done a video on, attracts a fine of up to £5,000 under the Tenant Fees Act 2019. The Renters' Rights Bill is introducing a decent home standard for the PRS. And if your property has a Category 1 hazard and you don't rectify it after receiving an improvement notice from the council, you could receive a 7,000 financial penalty under the Renters' Rights Bill, and also the tenants could apply for a rent repayment order. And don't think about being a bit fast and loose with trying to recover possession of your property without going through the due process of Section 8. And don't think about trying it on because you can receive a 7 grand penalty notice if you serve a notice to quit or ask a tenant to leave without using the proper form. And this would include serving a Section 21 notice after the commencement date. You can also receive a fine if you knowingly or recklessly misuse a Section 8 notice. And that's a very, very wide wording because you might genuinely believe that you have a right to the notice, but somebody might decide objectively you don't. And so that might be seen as being recklessly misusing a Section 8 notice, even though you didn't actually think that it was reckless. They look at it from an objective point of view. You can also receive a penalty if you mislead a tenant into leaving by using a false possession notice, or unlawfully evicting tenants or engaging in harassment. And if that happens, tenants will be able to apply for a rent repayment order as well. And to top it all off, even if the landlord does serve a Section 8 notice that's valid and uses ground 1, which is the families moving in, or ground 1A that the landlord wants to sell up, well, if the landlord relets that property or puts it on Airbnb less than 12 months after the tenant moves out or there's a possession order, that's another breach as well. So I promise the bonus at the end. Will you be able to challenge this penalty notice? Well, as I said, it's a bit like a parking ticket, although instead of receiving the parking ticket, you'll first receive a notice of intent to issue with a penalty. And this notice of intent will include the amount of the penalty, the reasons for proposing to impose the penalty, and information about how to make representations, which means to put your case. And so the landlord or the letting agent, as the case may be, will have the right to write in and make written representations to the council within 28 days of receiving the notice of intent. And 28 days isn't very long, particularly if you're on holiday or something. And if the council wishes to impose the penalty after that 28-day period ends, then they must give you a final notice, which includes the amount of the penalty, the reasons for imposing it, when it's payable, and your rights of appeal. And you will then have 28 days to appeal it to the first tier tribunal. And so you can appeal both against the decision to impose the penalty and the amount of the penalty. And also, don't hang around putting right whatever the breach is, as the fines will ratchet up. So what does this all mean for landlords and letting agents? You need to take the Renters' Rights Bill seriously. And if you're a landlord, as I said before, don't leave it to your agent. And if you're an agent, get some proper training. Make sure you understand it so you don't put your landlords at risk. And you're in the right place on this channel, as I have a free training course on the Renters' Rights Bill, and I publish updates on the bill regularly. And you can also sign up for my free weekly newsletter that I send out every Friday to thousands and thousands of landlords, lawyers, letting agents, and lots of other property businesses. And please give this video a thumbs up if you found it useful, and I'll see you soon.